All right, if I'm counting correctly, we're still missing a couple people, so I'm going to give people some time to show up before we get started here. I believe we're missing 2. All right, I believe everyone is here, so I will get started. So this is the process backfile check elective. Welcome, everyone. The goal of this elective is to provide a survey of the different process counterplan options that are available on this topic. This is both this is both an affirmative and negative focused elective. So I will mostly be talking about what the counterplan idea is, but I will also briefly give a discussion of what the various genres of affirmative answers to all these counterplans are. And at any point, if you would like to jump in and ask me more questions about a specific idea, or if you are interested in a specific idea I present and you'd like to see some evidence, if I have any, I would be happy to show an example or any evidence that I have on this issue. Often, so I guess before I get into specific examples, I want to clarify what I even mean by a process counterplan. Usually when I talk about process counterplans, I'm a stickler for precision about the definition of them, because process counterplans are a very contested term and it's important to be precise. But for this lecture, in the interests of being exhaustive, I'm taking a somewhat loose definition of process counterplans, and I'm broadly going to think about counterplans that try to achieve the quote unquote main part of what the affirmative does. And some of the counterplans that I'm going to talk about, I think many people would agree are not actually process counterplans. So it might be better to think of this lecture as more of just a broad counterplan, generic counterplan survey with a process counterplan focus. The way I will structure this is I will go through the words in the resolution, and I will talk about what the words in the resolution mean and how the words in the resolution can provide a basis for competition for different genres of counterplan arguments. An important theme on this topic also is modular preparation. So many of the generic counterplans that I will talk about might not seem like your definition of a generic, because these counterplans might not make sense against 100% of affirmatives on the topic. They might make sense against 30% or 50% or something. And my microphone sounds glitchy. Okay, let's see. Kevin, is this better?
Yeah, I think so.
Okay, thanks for letting me know. If there are more glitches, yeah, sometimes my sound is a little bit glitchy, so definitely don't hesitate to let me know. Kevin, thank you for pointing that out. So yeah, you want to approach your preparation through this perspective of subsets, where a lot of your generics are not actually going to be about all affirmatives, but you'll be writing these generics and counterplans, each to target a certain piece of the total affirmative pie. So the first words in the resolution are the United States federal government. And because the US federal government is the subject of the sentence, this set of words is usually the most conducive to competition arguments for agent counterplans. So obviously states and international counterplans are a common example, but there are also counterplans that come much closer to what we would think of as a process counterplan that compete primarily off of this word. Historically, the most common examples have been the uncooperative federalism counterplan, which has the states threaten the federal government with non-cooperation on a variety of policy initiatives in order to try to convince the federal government to do the plan. We have the Constitutional Convention counterplan, which has the states get together and call a constitutional convention in order to modify the Constitution to include the plan in a process spelled out in the Constitution's Article 5. And finally, we have the Interstate Compact counterplan. The Interstate Compact counterplan, I think, is much closer to a process counterplan potentially than the state's counterplan itself might be, because an interstate compact counterplan can replicate any of the benefits of a federal role other than really jurisdiction by creating a nationwide legal framework and nationwide coordinating authorities that would normally be unique to the federal government, but can also arise from the states voluntarily subjecting themselves to a new coordinating organization that they create themselves. International recommend counterplans or non-USFG recommend counterplans can also compete based on the USFG. If you think about it, the state's counterplan with its follow-on arguments kind of works like a recommend counterplan, because the state's counterplan is trying to say that the federal government would copy the plan. There are many other examples that make solvency arguments that are similar to this. On this topic, international actors that could recommend the plan are basically those that would typically be considered ones that are affected by the plan, or ones that could have some important viewpoint on the plan. And my list, non-exhaustive, but just some places to start, include the UN broadly, which has certain environmental frameworks. The UNEP, which I actually wrote down and I forgot what it stands for, is the UN Environment Program. So they could recommend the plan. The ICJ, which is the International Court of Justice, could recommend the plan. And specific countries that we share our water resources with, which are Canada and Mexico, could recommend the plan. All of these can use the USFG as the basis for competition. The final class of process counterplan that competes off of these are picks out of the, and I'm not talking about word picks, although those are also a thing, but picks out of the are going to be probably the way in which agent counterplans that are internal to the federal government come up, mainly. So like we don't have a great agent word in this resolution. So a pick out of the that argues that the word the implies the USFG is unitary, or that it has to be the whole USFG, coupled with a counterplan that does just the courts or just the executive. Those will, I think, primarily be justified through this approach, as well as slightly fancier agent counterplans, which might argue that the requires the USFG to act in a unitary fashion, so all together, and that fiated inter-branch conflict, so such as where the Congress does not support water protection, but an agency goes against the will of Congress in order to do water protection, and the courts uphold them and expand agency power in a way that's good. That could be an example of a counterplan that competes off of the, because it would argue that the position of the federal government is not that water protection should increase, because Congress has passed a law saying that it shouldn't increase, but then an agency, kind of a rogue agency, and then the courts would overrule the position of the US in practice. This competition argument is a little better for apps that involve international policy because of the literature that exists on the what's called the sole organ doctrine, which says, which speaks to the position of the US as a whole being represented by the president. So that is something to investigate. So that's the USFG. After the USFG, the next term that comes up in the resolution is should. And should is the mainstay of counterplans that compete on certainty or immediacy. This word is most commonly used to, it's most commonly defined as requiring the act to be certain or to be immediately implemented. This is kind of the bread and butter of traditional process counterplan competition. So what do we have under here? One common one is consultation counterplans. Who could we consult? The same usual international suspects, like the UN or the ICJ or Mexico or Canada, will be common candidates for consultation. Consulting the states in order to maintain intergovernmental relations is, I think, a common counterplan that comes up on a lot of topics. Consulting businesses, which would commonly be called regneg or regulatory negotiation, is also quite a common counterplan strategy that relies on should for competition. Again, those are just a couple of examples. Conditions is also, I think, going to be fairly popular. A conditions counterplan is a genre of counterplan that does the act if something happens. So the easiest conditions counterplan for me to think of, I think, would be a counterplan that ties US water protection to someone else's water protection, so to another counterplans, and says basically the US shouldn't do water protection unilaterally. The US should do it bilaterally through a treaty. So maybe if we're doing a border protection policy, this app would go to Mexico, and instead of just doing the border protection or the water protection on the border, it would say, like, Mexico, we will do this water protection policy only if you do your own water protection. And the net benefit would be that Mexican water protection is good, and that for leverage reasons, the two need to be linked. So if the affirmative just happens, that gives up bargaining power and prevents Mexico from saying yes to the condition. Another common idea that is discussed on the water topic in particular has to do with private and state funding. So
a lot of water policy, especially water infrastructure, is built using financial assistance from external parties like the states and the private sector. So a counterplan that does the plan, but on the condition that the private sector and states would be willing to foot the bill, can have a resource trade-off net benefit, because unlike the plan, which would not wait for buy-in from all of those actors, the counterplan would use the fact that the plan benefits some of those actors and impose a funding condition. This is one of those examples of a counterplan that definitely only works against a subset. Obviously, with a regulation affirmative, this will be pretty tough, but many affirmatives that do something to maintain water infrastructure are something that businesses and states really want to happen. So there is a higher likelihood that they would say yes to the condition and provide their resources. A related idea to this resources notion is a counterplan idea that has not come up in a while, but it is well, I actually think this is less a conditions counterplan than a study counterplan. So a study counterplan, this is another genre of counterplans that also compete off of should. This set of counterplans investigates the act and tries to figure out if the act is a good or a bad idea. And based on that, passes or modifies or doesn't pass the plan. The most common example on this topic will be the NEPA or EIS counterplan. So NEPA stands for National Environmental Policy Act. EIS stands for Environment Impact Statement. Sometimes it's also called an EIA, an Environment Impact Assessment. And as the name suggests, the NEPA or EIS or EIA process would assess the plan to see if the plan is beneficial for the environment. And if it is, it would do the plan. And if it doesn't, or if it isn't good for the environment, then it wouldn't do the plan. There are a variety of study counterplans that have come up over the years with different degrees of popularity. Really, usually whether these counterplans come up, it depends a lot on if people are able to find a specific solvency advocate for the topic. And I'm not sure which one of these will have one, but my prediction is, so human rights impact statement is one that has less connection to the topic than the environment impact statement, but has a similar premise. You check if the plan violates human rights. I think because of the amount of people who think water is a right, there will be quite a few people who talk about the human rights impact statement idea in conjunction with water topic proposals. The budget study, or I was going to call it a deficit conditions counterplan, will only do the AF if the AF can be made budget neutral. So if the AF can find ways to pay for itself, and then a benefit, of course, to that would be the plan's payment structure would be modified to pay for itself, and then the net benefit to that is the budget. Federalism impact statement is a counterplan I've heard people write, but I don't know if that's actually been read in a debate. But federalism impact statement is what it sounds like. It checks if the plan violates federalism principles. And more broadly than that, we have the Constitution impact statement, which checks if the plan violates constitutional principles. Then we've got what I would think is the broadest category of counterplans that competes off of the word should. And this is the broad bucket of recommendation counterplans / this increasingly popular category of apps that try to modify the political process in some way to cause the plan to happen. That last category is growing in popularity relative to just pure recommendation. So I'm kind of lumping them together because their competition argument is similar, because they're both saying neither of them fiat the plan, but they will both say that they do something to change the political environment, and that makes the plan happen. The most basic recommend counterplan, and the one that usually comes up on science or environment topics, is the decadal or decadal survey. I'm not actually sure which one it is. The word is decadal, like that. It's a thing that the National Academies of Science do every once in a while to try to determine a priority for US scientific research and science policy. I don't know if they've released one yet, but typically near the turn of the decade, there is a bunch of evidence written that they should do this and that the federal government follows the recommendations in decadal surveys. And those recommendations both resolve politics links and enable environment policy to fit within a broader coordinated strategy for environmental management. The commission counterplan also falls under this umbrella. The most basic version of a commission counterplan just creates a commission and has them recommend the plan and argues that the commission recommendation solves politics links. A slightly fancier version of the commission's counterplan is a version that follows what a lot of people call the BRAC model. BRAC was a process to close down a bunch of military bases the US had open around the world. And the way this worked was that the commission had some fancy powers, which was once the commission recommended a base closure, that base closure would happen unless Congress affirmatively stepped in to overrule the BRAC Commission's recommendation. That's a little better or a little more powerful because by default, the plan would happen. So Congress would have to step in to make the plan not happen. So the chances of say yes are a little bit higher because Congress is unlikely to step in and vote on anything about the plan due to gridlock. Those are my two picks for the most likely recommendation counterplans to come up. There's also a bunch of these inducement counterplans, and honestly, if people are fine with reading a fake inducement counterplan, like one with not a lot of evidentiary support or reasoning behind it, you can really do a lot with this category. A high profile example from recently was that there was a counterplan in the finals of the arms sales topic to, I forgot if they assassinated or impeached the president.
It was assassinate.
It was assassinate. Okay, so assassinate the president, and then you tell the vice president that the reason they assassinated the previous president was that they didn't do the plan. And then you just keep killing people until one of them does the plan. And the argument is that would happen pretty fast because they wouldn't want to die, I guess. And the net benefit was that Trump is good or Trump is bad because, and then if you kill him, that solves. But if you do a plan, then there's nothing to assassinate him over, I guess. So like you can't do it anymore. I don't know. The reason I bring this up is because it's total nonsense, but like what people can come up with on this front, it's like people are gonna be weird. I'm gonna name some real examples, but with this genre, it's really, really important as an affirmative team to be prepared with definitional presses to help defeat their firm to the counterplan responses. So be prepared to say that should does not require immediacy and certainty, as well as be prepared to loosely define some other words in the resolution. And arguments about the importance of normal, transparent, and predictable process to do the plan are also really helpful if you have an advantage about business confidence or an advantage about regulatory predictability of some kind. That can go a long way against counterplans like this in particular. My examples of somewhat real inducement or threatened counterplans. My favorite's the grand bargain counterplan. This counterplan puts the plan inside a bigger bill and has Congress put that bigger bill on the floor for a vote, and has the president lobby for it and does, whatever. Maybe Congress will make a statement. The Congress make statements in support of the bill or something like that. And then the team would read evidence saying that large environmental policy packages are likely to pass, and the permit, and obviously if the package passes, that solves the plan because the plan is in the package because of the negatives fiat. And the perm answer is that doing reforms piecemeal, so doing small reforms a little bit at a time, trades off with doing big reforms. So piecemeal reforms trade off with big reforms. Another one is just the counterplan to have Congress unanimously pass the plan, but not fiat what Biden does to it. And that competes because Biden theoretically could veto. But the net benefit argument would be that since Biden can sign it whenever he wants, he gets like some flexibility on when he wants to do it. That increases Biden's flexibility for when he wants to announce and commit to the plan, and that's avoids politics. Another idea is a congressional resolution supporting the plan. So the idea of this would be Congress passes a non-binding, not law, but a kind of public statement or public announcement in support of the plan. And then this counterplan would argue that the counterplan leads Biden to comply and it avoids politics because these congressional resolutions kind of go under the radar and are not noticed, but it would result in a binding law that passes down the line. Then we got threatened counterclaims. One that's been gaining popularity on CJR last year is the court threatened the plan counterplan, which is sometimes called the observer effect counterplan, because of the title of an article by a law professor from Vanderbilt who introduced this idea. And the observer effect, it's an analogy to quantum mechanics, which says that the behavior of stuff that you observe is affected by the act of observation. And so the metaphor is applied to interbranch relations. And this professor says, if the court makes it very apparent that they are reviewing what the president is doing and considering making a ruling restricting the president's authority, the president is very likely to comply in advance to avoid the court making a ruling that restricts their authority. So they'd be willing to do the plan even if they don't like it, to avoid a binding ruling that forces them to do it and constrains their flexibility. The net benefit to this is that the observer effect dynamic, where the president is scared of his own shadow and thinks that the court is about to overrule him all the time, is a productive dynamic because it keeps the president honest and it makes the president more deferential and more cooperative with the court, which might reduce things like the invocation of the state secrets privilege, which can be good. Also, it avoids a binding ruling, it avoids politics, all that jazz. There's also a different genre. I don't really think this actually fits under here, but I wasn't sure where else to put it. But then it's called the regulatory litigation counterplan, and this is the threatened businesses counterplan. Basically, we will sue you unless you do the plan. I guess that's the closest to a private counterplan, so maybe I should have put that there. But regulatory litigation is a thing. And then lastly, we've got this bucket against court affirmatives. Judicial sunsets says do the plan, but revise it or check if the plan is working 5 years down the line. And if it's not working, cancel it. This counterplan argues that the word should requires affirmative fiat to be durable, and also that the word resolved requires affirmative fiat to be durable. So making the plan open to revision 5 years later is competitive. The net benefit to this is usually court clog. There's also normal sunsets. So like even if the act is not a court act, people sometimes introduce the sunsets counterclaim, but judicial sunsets is much better. Neither of them is a winner, but judicial sunsets is better. I would say of all the counterclaim ideas on this list, this one has the most sketchy competition argument. A counterplan that I believe I made up for the TOC last year, but I'm not sure if it ever actually got read. So I'm saying it out loud for the first time. There is this thing called the shadow docket, which is it's a subset of the decisions that a court makes. So the court has like a normal merits, what's called the merits docket, which is the big court decisions that you tend to hear about. But there's also what some commentators have called the shadow docket, which is a more procedural focused docket where the court typically is not supposed to make merits decisions, but instead issues things like stays and injunctions, which are temporary decisions that are a procedural element of a broader case. So a lot of the decisions you've heard about recently, like involving Trump policies that required like very rapid resolution of issues, involved the court either striking down or imposing stays of what the Trump administration can or can't do. And that's all the shadow docket, or also called the emergency docket sometimes. This docket is not, the decisions on this docket are not final. So like I said, all of these stays, injunctions, and orders are temporary. Usually they're what's called pending appeal, which means they are in place until a merits decision can reach a final conclusion about what the law is on that issue. Oftentimes they can be a very powerful signal, though, of what decision is to come, largely because in order to issue an emergency stay or injunction or order, usually the standard that the court sets is the court has to be pretty sure how it will rule. So like if I, as the court, I'm pretty sure I'm going to rule a certain way, so the parties can't wait for the whole argument to happen to get their relief for some urgency reason. The court will issue an emergency order, but then still hear the arguments just in case they change its mind. So in situations like that, these orders, injunctions, etc., are strong predictors of which way the court will go. So they help by setting this precedent. And lower courts even follow them a lot of the time, but they are not binding and permanent like a final ruling is. Can I show examples or authors of the shadow docket? Yeah, the main person who complains about this is a guy named Stephen Vladek, spelled like that. Law professor at the University of Texas, Austin. Those of you who are DDI veterans might remember this name from the infamous FISA affirmative. Vladek said a lot of stuff about that subject. Yeah, I know. It's like cursed to bring it up even, maybe. All the staff are traumatized because it was way too complicated for people. But oh well. Stephen Vladek, yes. What happened to the FISA for this year? Yeah, I don't know. Sorry to disappoint everyone. I didn't have another FISA in me. Okay, I promised in the elective description I would tell you about some MSU files from 2004. So I think this is my first example of what is, it's like classic MSU 2004. The sunbursting counterplan. So sunbursting is a court process which basically it works like this. So normal court thing is an issue comes up and the court will just decide it, right? Once it like reaches the Supreme Court level. Sunbursting says, basically it has the court respond to a case by being like, we're not going to rule on this now. However, we agree with the legal rule that's proposed by the plan. And if someone brings this issue up again, we will apply the new rule, but we won't do it yet because we don't want to surprise people. We want to give people time to adjust. So the phrasing of that is out of deference to reliance interest. What that means is the court is taking into consideration all the people who are relying on the current rule and trying to minimize disruption for them. It solves the act because opportunistic litigants would be highly likely to bring a follow-up challenge and try to get the new rule enforced. But it competes because this would not necessarily happen. And the net benefit is that the counterplan does not require the court to rule sua sponte. Sua sponte means ruling without an underlying case to provide a test case for the new legal rule, or ruling on a case where the legal facts or arguments that have been presented do not perfectly line up with the decision the court wants to make. Sua sponte rulings are usually considered worse for the court's legitimacy. And as the negative, you can say that avoiding ruling sua sponte is really important for people to trust in the credibility of the court's decision making. That's the USFG and should. Any questions about any of that? Okay. Oh, yeah.
What's the net benefit to the threatened businesses counterplan?
Good question. Let me look it up. Reg lit. Yeah, I don't actually remember.
Okay.
It's politics, apparently, according to this file that I have, because you don't actually have to do any enforcement. You just have to threaten it.
Oh, okay. So would it like solve like businesses lobbying in Congress to like stop the plan from passing?
Well, no, it's the court doing it, so it wouldn't really be. It's like businesses lobbying is not really what the target is. It's just it doesn't require Congress or the executive to take a policy position. It just or it definitely doesn't require Congress to take a policy position. Some versions of this actually have state attorneys general threaten it, so that obviously avoids politics. But other versions, well, you can have the federal attorney general threaten prosecution and then argue that businesses will just comply because they don't want to deal with it, and Congress doesn't have to do anything. So that's kind of the idea there.
Okay, yeah, that makes a lot more sense. Thank you.
Yeah, there are two net benefits to the shadow docket counterplan. One is it avoids perception. So as the name implies, part of Vladek's complaint about the shadow docket is it's not very transparent. Nobody really sees what's going on. Vladek sees this as a bad thing, but obviously for our purposes, if people don't perceive what's happening, that can be a good thing also. Like it can avoid backlash arguments, it can avoid politics arguments, it can avoid court legitimacy concerns. There is also an internal net benefit about expanding the scope of issues that can be resolved through emergency procedure. Those arguments would not be solved by the perm, because if you do the full merits ruling and you couple that with an order, the order loses the qualities of an emergency order because the full merits decision has occurred. So that precedent is not set. While we're talking about courts, I want to mention a counterplan that is great against courts and you should use it, but it is for some reason not very popular, and that is grounds picks. Grounds picks say it's a pick out of the reasoning that the court uses to make its decision. So in some plan texts, the plan won't specify this and you can't do this, but if the plan specifies like we're doing this because we're interpreting the CWA or we're doing this because whatever, you can counterpoint to use a different set of legal reasoning. My favorite one, also I think never actually read in a debate, but I have written it for 2 different topics, is the preamble counterplan. So instead of doing it for whatever reason the plan said, you say that the preamble to the Constitution, so like the we the people part, legally requires the plan because it says that the government exists to protect the general welfare. And this requires environmental protection. There are law reviews that say this. The PERM wouldn't solve that because the court references the preamble all the time. And it's usually viewed as what's called dicta, or just like things the court is saying without intending for it to be precedential. But the counterplan alone would solve because it only relies on the preamble, which shows the court's applying it strictly and intends for it to have legal force.
What's the net benefit to that one?
The net benefit is it's good to give the preamble legal force. There's a bunch of different impacts to that.
Okay.
There is. Well, there's actually an argument that says. Oh, I didn't know you read that. There's actually an argument that says applying the preamble hurts abortion access. So that's a good affirmative impact turn to this counterplan. Excuse me, because the preamble says something about future generations. But on the flip side, you could. My favorite impact is, I don't know if you all are familiar with. It's a strategy Cal read. It was on the space topic in college, and they created a new branch of government using a constitutional amendment to like care a lot about future generations concerns and deliberately try to solve extinction and like plan for the long run and stuff. That impact was basically about making the government care about the long-term consequences of its actions, which solves extinction, and that can also be accessed by the part of the preamble that says the federal government has to care about future generations. Okay. Next word we got is substantial. This is usually just another certainty and immediacy word. And also sometimes it provides competition for picks via the definition of substantial that says it means in the main. So maybe you might say the counterplan is not affecting the main part of water protection. But this is not a good process word. Increase, also not a very good process word. Sometimes people refer to it as a justification for requiring certainty. But that's not great. The cards that say increase has to be certain are bad, which is something to be aware of. 2 genres of process counterplans that compete off of increase are offsets. So this genre says an increase in water protection means a net increase. So the counterplan would do the plan, but then it would reduce water protection elsewhere to offset the plan and make it so the total counterplan does not increase water protection. This one's weird. It usually works better on topics where you can like quantify what the plan is doing, because you need to like count how much the plan is increasing water protection and how much the offset is decreasing it to be able to tell whether the total is an increase or nothing or a decrease. You could maybe count it through number of protections. So if each protection is a legal if you define protection as legal restriction or something, you could say like we put in one law and we take away one law, so it's net neutral. Or maybe you could count how much money is being spent, so you would increase the planned spending but reduce it somewhere else. The perm would not solve this one under the theory that in order for a counterplan, in order for the neg doesn't have to disprove the plan, the neg has to disprove the topic. So like this argument says that the plan is only a reason to vote affirmative because it is an example, because it justifies the topic as an example of the topic. So it proves increases are good by giving an example of an increase that's good. But the perm to do the plan and reduce in another place is non-topical because the reduction offsets the plan's increase. So the counter plan is non-topical. So, you know, I don't know if you've ever heard the phrase perms can be extra topical, but not non-topical. That comes from here. So it's kind of like a topic severance argument because the perm, even though it includes an increase in water protection, does not in total increase water protection. The best affirmative answer to this is that that is a dumb way to think about counterplan competition, especially on a topic where you have protection as the thing you're offsetting, which is not something you can really count or quantify. But that is a thing that competes off of increase. Also, you got the new program counterplan. This program says increase means pre-existing, which means an increase cannot create something from zero. It has to expand an existing program. The counterplan would instead create a new program from zero, which it would argue is creation rather than an increase. And those are competitive options. And then it would be some disadvantage to using the existing legal framework to do the plan, whether that be an agency overstretch dissent or possibly a federalism argument to using the existing water policy framework. After increase, we have its. Its is one of low-key, I think, the best process words on this topic. Because even though you can probably think of a lot of different reasons why the federal government needs to be the one doing the plan, so any state's answer or argument about jurisdiction would be potentially an answer to the intuitive its arguments, but there are a lot of ways around that. Those of you who did my counterplan drill at the GDI might remember that one of the examples I picked for that was this idea that I had about deputization. This was the subject of a recent court case where the FERC, the Federal Energy Regulatory Commission, deputized or basically lent its authority to a private actor and told them that they can use federal power to take private land in order to lay a pipeline. This was recently litigated in the Supreme Court. The Supreme Court handed down a decision that was generally supportive of this notion, but a counterplan can expand the scope of deputization by giving a private entity the power to do the plan. You could even give them the money to do the plan if they need, but the net benefit would be that deputization is a good process to use. And the perm doesn't solve that because it adds in federal water protection, which is an incomplete deputization, since the federal government's still doing stuff, even if in partnership with a private actor. And that is well within the mainstream of what the federal government is accepted as being allowed to do, whereas the counterplan alone would rely purely on federal authority, which stretches the process to something new. Another privatization mechanism is land grants. So this is a little looser than deputization because the federal government's not giving away the authority nor is it really commanding the private actor to do something specific with that authority. What it does is it gives the private sector a grant for the land where the plan happens, on the condition that the private sector uses the property rights gained through the grant to do the plan. This works best against infrastructure affirmatives or against regulatory affirmatives that are geography specific. So let's say there's like a specific body of water, like a specific lake or river where we don't want a specific behavior. This affirmative would grant the rights to the land to a private actor and tell them to enforce, like on the condition that they enforce this environmental provision there. Or if we need to build a dam, you would grant the rights to the private sector to that area on the condition that they build it. And they would want to do this because they can make the money from the hydropower or something. These get even broader if you conceive of protection not just as what physically happens to protect the water supply, but as more generally things that rely on federal authority. So remember, I alluded to the idea of a protection as a legal prohibition. So if you think about protections as legal prohibitions, then its protections are those that rely on federal authority to make a prohibition. Under that framework, the most intuitive example to me of a counterplan that would compete off of that are counterplans that rely instead on some kind of supranational enforcement power. The IBWC could be an example of this. So instead of the plan happening through the federal government, you do it through the IBWC, and then the protection or the prohibition is not its, because the IBWC is partly outside the federal government. IBWC is not a great example because part of the IBWC is also within the federal government. But you're of course not limited to that. You can use any supranational entity or even create a new one and rely on their authority instead of federal authority for the enforcement for the plan. And that would mean the protection is no longer its because someone else is in charge of it. Even if, again, the federal government is the one kind of enforcing it or carrying it out. Because again, if protection is the prohibition and the prohibition is someone else's, then the authority is someone else and the protection is its. Next, we have got protection of water resources. These counterclaims have the worst solvency because they pick out of the topic phrase. So any justification for doing the topic mechanism will answer these counterclaims. However, it is often worth it because competition is getting to be more of a problem for process counterclaims than solvency. I would happily almost always take like a 30% hit to solvency in exchange for a 30% improvement to competition arguments. Because once you've proven that competition happens and you're solving most of the case still, because it's still kind of a processy counterclaim that does most of the spirit of the act, you're in a great spot, and you're usually going to be able to outweigh the residual difference using your net benefit. So first set is based on definitions of protection as being prospective, so protecting water instead of trying to fix it at the back end. There are some things you can do with this as in order to get counterclaim ground. So one is if protection has to be stopping pollution rather than retroactive, you can counterplan to not stop polluters or people who will damage the environment, but instead punish them after the fact. So let them pollute the water, but then come after them afterwards. So you're not stopping them from polluting, you're only enforcing it retroactively. This could be better because it's less resource intensive. You know, you don't have to look for all the possible violations and stop them ahead of time. You just have to punish a few people after the fact and solve through deterrence and perception. And you can also get net benefits to this by using a fancy process for the punishment. So for example, you can say bills of attainder should be passed for people who violate the plan standard. A bill of attainder is a constitutionally prohibited process that passes a law that targets a specific person or group and accuses them and makes those people criminals for doing something. It's unconstitutional because it violates due process. But many people argue that bills of attainder, the prohibition on them should be relaxed for companies in order to enable more enforcement options for unscrupulous corporate behavior. So that would be the net benefit to that. And obviously, these counterclaims would also make a spill up or follow on argument that say the sporadic enforcement would eventually result in the plan. But hopefully it solves the net benefit in the meantime. Then we've got the protection picks that compete based on the idea of protection as a legal prohibition. So this is what I alluded to earlier. These counterplans are basically a regulation pick or like a ban pick. And my most intuitive example was the fee or royalty counterplan. So fees and royalties, the difference with those is they don't say you're not allowed to do the thing. What they do is they make doing the thing really expensive. So it's not like a fine, because a fine says you're not supposed to do this, and the fine is your punishment for doing it. The fee or royalty says you are allowed to do it, just only if you pay. The difference with that is a couple things. One is for the price of letting a couple people do it, you can collect a bunch of money and you can then counterplan to spend that money for something that is good. The firm does not solve that because it does not create money to spend on whatever you want to spend it on. So you can steal the money and spend it on whatever you want. Also, business confidence and economy arguments can be a net benefit because you're not criminalizing or making a categorical rule. You are just trying to raise money. So if someone desperately needed to continue doing whatever activity the plan prohibits, the counterplan lets them pay to be able to continue doing it. So there's a minor difference with BizCon as well. You can also pick out of water. You can protect the land instead of the water. So if there was going to be pollution, like if you are banning like pesticides or something because they hurt the water, you can ban the pesticides because they hurt the land. And the benefit to that would be, you know, you're accomplishing the same thing, but you're not using the water policy legal framework, which avoids politics links about water policy, and which are that argument's bad. But a little better is it avoids precedent links to federalism based on water law and the precedent set by water policy. You can also counterplan, instead of saying we should do it on land instead, you could do an entirely different body of law altogether and say it's not about water protection, it's about public health. So we're banning the same activity, but we're doing it because it hurts people. That one has a much better policy or politics argument, because you can say it's a health policy, not a environmental policy. And it's not a water protection because, again, water protection has to be a prohibition on doing something to the water. And the counterplan would not do that. It would prohibit doing something somewhere else, which would incidentally affect the water. These counterplans are really good against those apps that are clearly not water policy, but are trying to get backdoored in because they affect water as a side effect. So like ICBMs, classic example of something you could solve with a counterplan like this. The last phrase in the resolution is in the US. This is also not a great process phrase. However, there's one set of counterplans that does arguably compete out in the US, and that is picks out of restricting the plan based on geography or nationality. Sometimes this is called the universal counterplan. And what this argues is that putting the phrase in the US in the plan is not a negative restriction on where the plan can reach. It's a positive action that creates a legal framework for discriminating between in the US and outside the US in the application of the plan's law. So it's a legal framework that positively discriminates between the US and outside the US. And the counterplan is a pick out of that. It says do the plan, but make it also apply extraterritorially. This is the best with like rights affirmatives. So if the app says give water rights or water should have legal personhood, it would be odd to say water in the US should have legal personhood, but water outside the US is not a legal person. So a counterplan like this would say, get rid of the part of the court decision or statute that specifies that legal personhood is only conferred to waters in the US. And by omitting that clause, the plan would then become applicable everywhere. And that benefit is that universality of application is a really important international law principle, which is great for international law compliance. Yeah. That is what I got. Questions about any of the ideas that I talked about or any other ideas? All right. If more questions come up, feel free to chat with me in the office hours. Is there a document that I can share with my list of counterplans? Yeah, I can maybe share my notes about this. I actually wrote them by hand, but maybe I can like export this and send it to anyone who is interested. Just come to office hours and then remind me to do that, and I will send it to you if you want it. Whether you'll be able to read my handwriting is another matter entirely, but that is your problem, not mine at this point. Sorry. All right, if there are no other questions, thank you all for being a great audience, and go to your next elective.
Thank you.
Can I give you your actual process, my actual process counterplan back files? I think you know the answer to that. The answer is you have to pay me for them.